biggest crook in the world. Can't imagine who he seems like to anybody. His name was William Blount, and he bought himself, or his dad bought him a paymaster position. He used that position during the Revolution to not have to fight, and then used the money to buy a bunch of land. And then he fomented war with the United States so that people would flee the already civilized area and go to his western land, like in Tennessee. Tennessee was really far west then. And so he was just this huge crook, but he was a really handsome swindler, and he got away with just murder. And so the House, by the way, he signed the Constitution. This is a Constitution signer that was impeached. He was a big crook on a big scale. He refused to show up. The House impeached him, and he didn't do anything. He never answered anything. And the Senate, before they had a trial, this is apropos to your question, the Senate, because he was a senator, just kicked him out under Senate rules. They just kicked him out. And they actually had a mini trial because the senators were able to identify his handwriting on the stolen dispatches where he'd been fomenting war with the United States. And he denied it was his handwriting. And they said, well, sure as hell is. We sit next to him, and that's his handwriting. And so he was kicked out. And then the House finally got around to technically sending the impeachment articles a year later. Communications difficulties back in the 1790s. And they sent the articles of impeachment, and then they finally sent them to the bar of the Senate, which is the official way to do it. You put the articles in a hopper, the House votes on them, the House then literally, physically gives them to the Senate across the bar of the Senate then starts a trial. Well, the Senate had already had this little mini trial, but then they had another trial. And things were really confused, and the procedures are a little screwy. And then during the trial, there was motions made to dismiss because two reasons. Number one, well, this is a senator, and surely congressmen can't be impeached, right? Let's not impeach ourselves. And number two, he's not a senator anymore. He got kicked out, so this is void. And they were granted. So the rule from the Blount case is Congress can't be impeached. That's a Congress-made rule. And seriously. And also, you can't kick somebody out and then try them, which also makes sense. There's a lot of strange procedures, but keep in mind, this was a totally new rule. A lot of the state governments under the Articles of Confederation and under other provisions, a lot of the state governments did have impeachment articles. Madison, who was a genius, and Mason wrote some wonderful such. Jefferson knew about them too. So the U.S. was pretty familiar with articles of impeachment, but it wasn't until the Constitutional Convention that the U.S. really got down to the specifics of how it would work. And John Adams tried impeachment cases. He defended the Boston Massacre defendants, the British soldiers. John Adams was a great lawyer and knew a lot about impeachment. Jefferson had tons of books on impeachment. These people were very learned about the difference between what was happening in England and what was happening in the United States. And you'll see a lot of books, really fancy books by fancy law professors out there, real thick, and some really thin, including one by Charles Black, a very famous he's dead now, but a famous old Harvard law professor. And a lot of them say, you don't really need to understand British law. It's just very complicated. All you need to know is what's common sense. Use your common sense about what high crimes and misdemeanors mean. It must be a crime, must be a misdemeanor. It's just not true to say that you don't need to know British law when it serves as the basis for what the founders didn't want. They wanted to stop high crimes and misdemeanors the way they were defined under the British king. And as a matter of fact, Parliament has done away with impeachment British style. Because, that's a good question. The reason is, Impeachment in Britain was unaccompanied by a written constitution or a constitution that had civil rights, due process, no ex post facto law. And so impeachment allowed the authorities, including Parliament, to impeach somebody after the fact by still defining treason broadly. And there was no protection, as was written. And we know specifically that the reason the definition of treason is so narrowly defined, by the way, nobody ever pleads constitutional treason against anybody, because it's the hardest thing in the world to prove. You need 2 witnesses, you have to do it, you have to confess in open court. Not very many people do that, to confess constitutional treason. So the reason why is a very good reason. The British Constitution doesn't have the civil rights protections we do. And we have civil rights and other due process protections because the British law sucked on that. If you were just a regular commoner, you had no rights, and if you were a lord, you were subject to capital punishment if you pissed off the king. So he was the law. And the main thing, and the reason I say betrayal of trust, everybody was worried that we'd develop another autocrat. Trump is exactly who they had in mind. Okay, I'm a little partisan.
What I was asking was, with your knowledge of what you've been a lawyer and everything, do you think that they're going to be able to do anything in 2 years to Trump?
This is a really hard question. Do I think they're going to be able to do anything in 2 years to Trump? As far as capability, yes. The streamlined rules are great. If you asked me this question in the 18th century, I'd say, don't see it happening. In the 19th century, maybe not. But ever since post-World War II, the rules have been streamlined increasingly, because in World War II, there wasn't much talk of impeachment other than people occasionally mad at Roosevelt, because things were so concentrating on defending the United States and prosecuting World War II that people thought, we never will be able to do it. And then there was a whole flurry of impeachment activity, and that's when they started streamlining. So the first part of your question is, we have the capacity to do it, Congress has the rules to do it, they've got their act together, and I gotta say, you have experienced prosecutor in Adam Schiff. And also Cummings, and there's a couple of other congressmen who really have done great jobs. So I think it's doable. Does Pelosi want to do it? I think that's going to be a huge question. But if they tangle him up, if they impeach him in the House or take a while to do the hearings, that may have a beneficial effect. And the House can do it efficiently. And it's another arrow in their quiver. Let me say, it's much better than the 25th Amendment. 25th Amendment ultimately requires 2/3 of the House and 2/3 of the Senate. And you've got to have all this, you've got to have evidence of his nuttiness. Okay, you have to have psychiatric evidence of his nuttiness. But the 25th Amendment, therefore, requires 2/3 of both bodies.
What is it?
That's the one that has both the line of succession and removal of the president for incapacity. But if the president is incapacitated or incompetent or negligent or just a jerk causing terrible harm, he can be impeached by 50% plus 1 of the House, not 2/3 of the House. So going through an untested 25th Amendment makes no sense. By the way, the 25th Amendment is appealable to the Supreme Court. So your point, perhaps, I really should emphasize this more. The point of being tied up in court is the main reason why anybody who tells you we should be doing 25th Amendment instead of impeachment has lost their mind. Because the problem, well, that was not intended that way. The problem, yes sir, the problem with the 25th Amendment is that, let's say it happens right at the end of the 4-year term, then you appeal it to the Supreme Court, and he wins or loses, and there's somebody new in there. And the reason the Supreme Court decided that you could not appeal impeachment was it makes no sense at all. If you've removed him or her, by the way, no woman has ever been even impeached. Just saying. If you remove him, then that's what the Constitution says is to be done. If he's removed, then how dare he appeal? This is what the Supreme Court said. How dare you appeal so that in the next term, somehow we put you back in office and we throw out a duly elected person? That's not what the Founding Fathers had in mind. And it is my guess that if the 25th Amendment succeeds on anybody, on a president, and they put somebody in due to 25th Amendment certification of psychiatric or whatever incapacity they have, not of death. I mean, I understand succession or resignation and all of that, or being impeached and therefore you get next in line. Succession is fine, but to put somebody say somebody is rendered incapacitated, never done before, except voluntarily twice by guys having colonoscopies, and eventually you come back from a colonoscopy. One comment. I'm married to a doctor, so I think you know. The issue of when you hear people talking about 25th Amendment, remind them that what happens if you appeal the 25th Amendment removal. We know what happens in impeachment. You lose. There's no question. There's no appeal of an impeachment. Anthony Kennedy was a concurrence in that decision. Anthony Kennedy, who recently resigned after he wrote the travel ban case, concurrence, and after he joined in with agreeing with the Muslim travel ban. Anthony Kennedy understood impeachment. I'm going to end with this, please. But it's something I feel so strongly about. Anthony Kennedy in the Nixon, by the way, the name of it's just a coincidence, the judge who was impeached who appealed and made great law saying an impeachment can't be appealed to the Supreme Court was named Nixon. So the name of the case is U.S. v. Nixon. Not the Watergate tapes case, that's Nixon v. U.S. Maybe it's got them opposite. Judge Nixon lost. And because Judge Nixon lost, we have this great decision joined by a very smart judge, Anthony Kennedy. Then we have the travel ban decision decades later. And the travel ban decision is one where you may recall Roberts bent himself backwards to say, you know, this really isn't our job to interpret the Constitution. What the heck? It was an amazing gyration. You know, Nadia on the bars couldn't have done better. It was outrageous. But there was a concurrence in the case that's the saddest decision, saddest writing I've ever read. And it's by Kennedy. It's very short. And the concurrence in the travel ban decision basically says this. A high officer, and there was only one high officer being discussed in the travel ban case, that was Donald Trump. It said, a high officer, we have held, cannot be held to a constitutional review of his misconduct. And therefore, there are things that the Supreme Court, from a constitutional interpretation standpoint, just can't do. And this is I think this is within a month before he ends up resigning. It is just this last gasp of, oh my gosh, there's nothing there's nothing that the court can do. So here is Anthony Kennedy saying there's nothing the Supreme Court can do, and we know, and he says, you know, he said basically Congress enact a law, because we're interpreting a law to favor the President of the United States. So he's calling on Congress to enact a law to not allow the President to make the interpretation he has now just successfully made. So he's saying, we the court can't do anything. Congress, you must do something, and as you know, Congress did nothing. And so he's basically saying there's only one choice, because Trump's not going to control himself. He's saying there's only one choice. He's saying nothing more can happen. All that's left is impeachment. He doesn't use the I word at all, but it is the travel ban case is by Anthony Kennedy, and he knows of what he speaks because he wrote that decision that said, the concurrence with Rehnquist that said, you cannot appeal impeachment. That's the only, I read him as saying that's the only solution. Okay. Well, I have books here if you want me to sign or sell. And if you want to follow me on Twitter, I'm TX Barbara Ann. TX Barbara Ann. Thank you, dear. And she's worth listening to. We need better applause, please.